Hi, I'm Kirk Evans, president of U.S. LawShield, and we're here today to talk about a recent decision out of the U.S. Court of Appeals for the Fourth Circuit, which held that a portion of Maryland's handgun permitting laws was unconstitutional. So we'll do that in three ways. One, we're going to talk about what the Court of Appeals said. Second, we're going to talk about what that means for gun owners or folks who want to become gun owners in Maryland. And then third, we're going to talk about what the Court of Appeals did not say, because there's some very important aspects to what the Court of Appeals did not say. So first off, what did the Court of Appeals say? The Court of Appeals was very concerned about a portion of the Maryland handgun permitting regulations that require someone to wait as long as 30 days before they find out whether or not they get their permit and whether or not with that permit they can then have a handgun for self-defense. So in Maryland, right now, if you apply for a handgun permit and turn in everything that's required, your fingerprinting, your background check, and all that, you may have to wait as long as 30 days before you find out whether or not you get that permit. And the Court of Appeals said that it's unconstitutional to have that blanket prohibition on you exercising your constitutional right, where you have to wait 30 days to find out whether or not you can exercise that right. So, what does this ruling mean for gun owners or folks who want to become gun owners in Maryland today? Today, actually nothing. This decision is not final and does not impact gun owners whatsoever until the Court of Appeals issues what's called a mandate. And they will not issue a mandate until 7 days after one side or the other has had a chance to ask for a rehearing or a stay of the decision for further proceedings, or the case may even go up to the U.S. Supreme Court. So right now, as it stands, the law has not changed. If you do not have a permit to possess a handgun in Maryland, you cannot go out and get a gun today, and you cannot carry one, or you will be in big trouble. You can be arrested, even charged, even convicted of the existing crimes as they are in Maryland. Even if this decision becomes final, expect further procedural wranglings where Maryland will go back, look at the decision, tweak their laws, and then you may have additional challenges. If they tweak their laws, someone may challenge that again. There may be further appeals, may even go up to the U.S. Supreme Court, where one day we might get clarity as to what the law is in Maryland. So again, right now, nothing has changed. Look for further updates. So third, what did the Court of Appeals not say? The Court of Appeals did not rule whatsoever on the wear and carry permit regulations in Maryland. So that means if you want to carry a firearm around in Maryland, you still need to get a wear and carry permit. This had no impact on that whatsoever. Second, this decision has no impact whatsoever on prohibited persons. So what does that mean? If you are barred under Maryland or federal law from possessing firearms, say you have a felony conviction or misdemeanor domestic violence conviction that would otherwise prohibit you from having a gun in Maryland or under federal law, this decision has no impact on you whatsoever. You still cannot go out and possess a firearm in Maryland. The good news for U.S. LawShield members is if you have any questions about this whatsoever, you can call in and ask to speak to your independent program attorney there in Maryland, and they can walk you through any questions you might have about going out and purchasing a firearm, owning one, whether or not you need a permit, how this decision might apply to you. For everybody else, for more information, go to uslawshield.com, and thank you for watching this video.